So good afternoon, everybody, and welcome to this webinar. My name is Rónán Kennedy. I'm a lecturer in the School of Law in NUI Galway. And I'm going to present the results of some research that I did in late 2020. At the time, I was a Science Foundation Ireland researcher in residence in the Oireachtas Library and Research Service. I'm funded by SFI, obviously, as you can see from the logos on the screen. This particular scheme that I was part of was part of an effort by the Oireachtas Library and Research Service working with SFI to give the members of the Oireachtas more awareness and more, I suppose, advance notice of issues around various STEM questions that could benefit from, or perhaps might need some legislative attention in the future. And there was a concern that the members of the Oireachtas are not necessarily as up to speed on STEM issues as they might be, and that it was difficult for them to get access to good sources of information on STEM issues. So they had this particular public service fellowship scheme, and I participated in it. I essentially was on secondment to the Oireachtas Library and Research Service for 3 months. Unfortunately, although I had hoped and thought that when I applied for it, that I would be able to spend some time in Leinster House and see how the legislation is actually made day to day. That didn't happen because all this took place in the first period of the pandemic. So I was essentially stuck in the same place that I am today. Stuck in my home office and doing the research at a distance. But nonetheless, I was able to engage quite deeply with the topic, and I'm very grateful to SFI for the funding and for the opportunity that it gave me, and also to the Whitaker Institute for the opportunity to present that research this afternoon. Just a little housekeeping note maybe before I go into the presentation proper. If you have questions, take them at the end, I think, just so that I can manage the various elements of the technology here while the webinar is going on. But if you have questions as I'm going, you can type them into the Q&A aspect of the Zoom interface, and I'll come to them towards the end, or also entirely possible for people to unmute themselves later on. But just while the presentation is ongoing, I think we might hold the questions until the end. So let me begin then by talking a little bit about the context in which I conducted this research. And one of the things I sometimes say to my colleagues, and I'm maybe being a little bit unfair, but there is some validity to it, that in many ways what we do in terms of legal education and training is we prepare lawyers for legal practice in the 1850s. And that maybe isn't necessarily all that inappropriate, because not an awful lot has changed in any deep way about the practice of the law since maybe when Dickens was writing his great novels about various long-running legal disputes. And if we could conduct a little thought experiment for a moment, if we were to, by some magic, transport a doctor from, or a nurse perhaps, from a hospital in the 1850s, 1860s, 1880s, and drop them into a modern hospital, they would be completely confused and very confounded by all of the technology, the bleeping screens, and so on that they would encounter. The world of medicine, like many other professions, has been radically transformed by technology, and particularly by information technology. But if we were to, again, by some magic, transport a lawyer from a courtroom of the same period, that lawyer would be relatively comfortable. There wouldn't be an awful lot in that courtroom that would be different to what they are already, that they would have been used to. They would see a small amount of technology. The image there on the screen has a laptop or something in front of the court clerk. In an Irish context, there is a big digital display, which is the time signal for the digital audio recording system. But to a large extent, the work of, certainly the work of advocacy, the work that lawyers do in court hasn't changed all that much. There's still an awful lot of paper. And in terms of solicitors' offices and so on, yes, there is technology, a lot more reliance on things like email. But when you sort of look at what's really been done, you know, the work that is taking place, it is not that radically different from what was being done 50 years ago or 100 years ago or 150 years ago. It's just been done maybe a little bit more quickly and with a little bit more polish. But the fundamental work of lawyers has not changed in that time. But there are indications that that may be changing now, in some ways changing radically, in some ways maybe not changing all that radically. And I think there's, as often is the case with issues around information technology, there is a lot of hype. So this research that I conducted and this presentation is going to try and map that out a little and look at where the issues are, and maybe examine some of the hype as well and raise some questions for discussion. But before I go into that, maybe we should define our terms. What I'm talking about in this presentation is legal technology, the use of information and communications technology for legal practice. It's sometimes called legal tech or law tech, a variety of other sorts of labels that are given to it. And there are a lot of different definitions and different ways of classifying this. But one broad definition is one that's been used by the Law Society of England and Wales, who've done quite a lot of work on this. And they talk about technologies that aim to support, supplement, or replace traditional methods for delivering legal services, or that improve the way the justice system operates. So that is a very broad definition. It would capture quite a lot of different types of technology. And some of them I think are more interesting than others. And particularly from my perspective as a researcher, and also from my perspective as an educator, as someone who teaches students about the law and tries in some respect to prepare them for legal practice, for a career in the law and different aspects of the law. The verb that's particularly interesting in that definition is replace. So supporting and supplementing, okay, well then we're doing things a little bit more quickly perhaps, or a little bit more cheaply, and that can be interesting. Certainly it can enable new business models and new approaches. But if we're talking about replacing traditional methods for delivering legal services, then lawyers and people outside the law should be looking at this more carefully and asking, well, what is actually happening here, and is this beneficial, or could it have some negative consequences that we might prefer to avoid? So let's look at that in a little bit more detail. And the image on the screen is an attempt to present a classification of these types of tools. And we might go around anti-clockwise. In hindsight, I should have maybe arranged the diagram differently so I could do it clockwise, but it's anti-clockwise sort of follows the historical development of these kinds of tools. And there is a perception, and I've sort of alluded to it in my introductory comments, that lawyers are quite conservative, and certainly law can be quite a conservative profession and sometimes reluctant to adopt new technologies. But in fact, lawyers were amongst the first to adopt the use of large-scale databases of textual documents as far back as the 1950s and the 1960s, when computer technology first made this sort of thing available. I think it's just a hypothesis of my own that perhaps one of the reasons why we've lagged behind so much now is because we were early adopters and sort of stuck with a certain stage of the development of the technology. But in any case, lawyers we're the original information workers. Lawyers, fundamental raw material is the written word, and certain lawyers and certain computer scientists were quick to realize that if you could gather large amounts of legal texts together and make them easy to search, then it would make the day-to-day work of a lot of lawyers very easy. So we were using online databases from a very early stage. We then moved through on through the 1970s to a small extent, certainly through the 80s, the 90s, to start to use these tools first to support the kind of work that was happening in offices. So word processors, replacing typewriters. We started to use digital technology to manage the work that goes on in a legal office, to manage the process of cases and projects. So this could be litigation, or this could be a merger and acquisition. It could be a lot of different things. And to a large extent, these tools are essentially the same as is used in many other contexts as well. So there's nothing necessarily unique about to the law about this type of use. And then through the 90s, 2000s, we began to use these technologies more for things that are specific to the legal profession, but were by and large supporting or making more efficient or faster things that we're already doing. So some courts began to allow the documents to be filed electronically. Lawyers started using screens and slides and so on to present in a courtroom. We began to record what was being said in a courtroom digitally. And some courts began some limited experiments with remote hearings, generally just for particular individuals, witnesses who couldn't travel, or children who might be intimidated by a courtroom might present by some sort of video link. So these are the application of the technology to, as I say, to support what's already happening. But what's begun to happen in the last, we'll say, 7 or 8 years, although it has roots much further back, and there have been experiments in this direction from the 1980s and 1990s on, is that in common with a lot of other contexts, the development of so-called artificial intelligence, the development of machine learning, the development of more sophisticated online tools have meant that there are now some software applications available that claim that they can implement some sort of independent decision-making around legal questions so that they can help with negotiating solutions to disputes between parties, that they can maybe help judges to adjudicate issues, that they can engage in legal research essentially, and they can solve legal problems, that you can ask a computer what the answer to a particular legal question is, and it will provide you with the answer in the form of a memorandum or something like that. These tools can help to manage the huge amounts of information that lawyers must deal with in practice. That these tools can actually draft documents to be submitted to a court, so that you, if you're being sued, you simply pass the legal documentation onto a artificial intelligence program, and it will draft a response to those. These kinds of tools are out there being used to a limited extent, but they are being used by lawyers. Online dispute resolution has become something that has a lot of application, particularly in the context of the online marketplaces like eBay and Amazon. And we're increasingly beginning to see lawyers and NGOs and so on using chatbots, which essentially will get information from somebody and advise them on their initial options, or perhaps gather information from them in a triage process, so that this can be passed on to someone who can really answer their question, someone with expertise. But the sort of initial 30 or 40 minutes of the interview where the information is gathered is being done automatically, because you'll always be asking the same set of initial questions to try and find out what the background to the query or the dispute or whatever is. So this is the area that I think is most interesting, the independent decision making, because it could transform the sort of work that lawyers do. It could have a lot of positive benefits for the public in terms of making access to justice easier and cheaper and more convenient. And from my perspective as an educator, means that I might need to train or educate our law students with a different set of skills and a different set of knowledge and a different set of awareness, because these tools are dependent on artificial intelligence, and I'll come back and talk about AI maybe a little later in the presentation, but they are not going to operate in the way that humans do. A lot of AI tools or machine learning, I tend to think of those more as marketing terms. Machine learning really are sophisticated statistical models. They're not really thinking like a human, and they will make mistakes, they will make errors, and more importantly, they will make mistakes that humans wouldn't make. So if you're going to work with an AI, you need to be aware of its strengths and weaknesses and be able to mitigate against the ways in which it might fail, which will be different to the way in which a human will fail. So all that raises a lot of interesting questions for me as a legal educator, but I think it also raises interesting questions more broadly socially. Let's talk a little bit more about Ireland in the Irish context. So there has been some use of these types of tools in the Irish marketplace, but it seems that to a large extent we rely on the development of tools for the UK and maybe import them here. There are some limited startups and so on working on this here, and it's clear that a lot of the larger law firms are relying very heavily on AI tools. And these types of technologies. A lot of them have their own digital services units and so on, but we haven't really developed a native or domestic market here quite yet. At least that seemed to be the situation when I was engaging in research in 2020, and I'm not sure that it has changed that much in the intervening period. Nonetheless, these tools are important. They could have quite significant economic implications if there isn't a very well developed indigenous industry that is actually has potential growth implications. We could develop this kind of industry, given that we've been so successful in developing software-based industries and companies in other categories, and we now have the advantage that the UK is no longer in the EU, so that might give us benefits from, for example, a data protection perspective into the future. And there are also potential implications in terms of reducing legal costs and in terms of, as I say, providing access to justice. So there are a couple of different ways in which this might happen. I've already alluded to the idea that these types of tools might create documents automatically. And that has the potential to save a lot of the drudge work, I suppose, that a lawyer would do, which can be quite expensive. There have been proposals and some unsuccessful and successful projects in other jurisdictions to simplify and streamline what's involved in conveyancing the purchase and sale of land, and to do that electronically. And certainly that has a lot of potential, but experience here in Ireland has not been so positive. The Law Society of Ireland has done a significant amount of work on this and has had to cancel a project at a cost of something in the region of €2.5 million, apparently, and is now looking at perhaps learning from Australia, which has had better luck with this. There is also the possibility that lawyers might be able to use artificial intelligence and machine learning tools to look at contractual documents and to identify where there might be potential problems with the drafting of the clauses in those contracts and to improve them to reduce the likelihood of dispute or to reduce the likelihood of litigation if there is a dispute around the contract. So those are things that could have some positive economic benefits. And one of the things that is often said about legal costs in Ireland is that they are too high. The Law Society of Ireland takes a different view and points out that legal costs are not actually identified as a barrier by many people in a real sense in practice, and also that it is skilled work. So perhaps it needs to be expensive. But that's a broader debate, maybe a little bit outside the remit of this presentation. So I'll move on from that and talk about the social implications of this. So we could possibly see better access to justice in which individuals can, who have unmet legal needs, and there are people talk about an iceberg of unmet legal needs, and that there are many individuals who would like to get access to legal services for a variety of different things. It might be disputes, it might be just generally knowing what their legal situation is, and they can't do that because access to the law is simply too expensive for them. So AI tools and chatbots and a variety of other things might provide a way in which people can get easier access to this kind of advice without jumping through all the hoops that are necessary or incurring the kinds of costs that might be involved. And that could be generally a social good. But I'm not sure that legal tech is a silver bullet to solve this problem. Research does indicate that, in fact, the reason why most people who have unmet legal needs don't access them is not actually really cost. It is often about other barriers, and in many instances, it's because the problem that they have, or the need that they have, is one that carries, for example, a lot of emotional weight. So many people, for example, don't have wills. And the reason that many of those people don't have wills is not because they can't afford to draft a will, but because they're not willing to deal with all of the emotional questions that's going to bring up for them, perhaps in terms of their own mortality, but also in terms of making hard decisions about where their assets are going to be, to whom their assets are going to be distributed after they pass on. So certainly part of the access to justice issue is cost, but it's not the only barrier. So legal tech is not by itself going to solve that problem. There are also some ethical implications from the use of these types of tools. Remote hearings is something that I mentioned earlier, and this had been very much a minor thing in practice in the legal system here and in many other jurisdictions until obviously the pandemic. And if you have been paying attention to this, you will have seen that many of the courts switched to online hearings. And there has been some limited research into how well they functioned. And by and large, most lawyers were happy with them. They didn't feel that they were terrible. They didn't feel that they would not serve purpose, but they did indicate that they were unhappy with aspects of how they operated, in that they weren't able to get time for proper consultation with their clients, and both judges and lawyers found that the experience of conducting legal discussion or legal arguments over a video link was really quite unsatisfactory. And there are broader questions as well about whether or not remote hearings are appropriate in the first case for this type of situation, with some people essentially feeling shortchanged by the experience, because instead of the ritual aspects that go into a court, what was happening was that essentially justice was being dispensed from the judge's sitting room or dining room, and the whole majesty of the law, which is sometimes part of what people have an emotional need for, so that they feel proper closure, was missing. But I think remote hearings are probably going to be continued for certain types of hearings, certainly for the more routine, short administrative hearings that are part of the sort of the preliminary to a full hearing. There's a lot to be said for them in that particular context. The other ethical issue that arises here is questions around bias, and bias particularly in machine learning. So I did mention very briefly that there are the development of some of these types of tools that are aimed at essentially independent decision making, and sometimes to support judicial processes. And that has been a topic where there has been some considerable development. In the US, these types of tools are used to support judges in making decisions around sentencing and around bail. Other countries like China and Pakistan are also very keen on the use of AI. Estonia apparently has claimed that it is going to use an AI tool to deal with small claims cases, but I haven't actually seen any evidence that in practice, so that might be just another example of sort of hype that surrounds all this. And certainly, if one could make these types of tools work well, so that the legal system and the court system particularly, which often have huge numbers of cases with significant backlog, can work more quickly and efficiently, then that's to be welcomed. But as I've said already, artificial intelligence isn't really intelligent. These are basically statistical modeling. And in many instances, that statistical modeling is dependent on looking at the past, and the data from the past will often embody the sorts of biases and prejudices that have been applied by human beings. And it's very difficult to purge the data of that. So we could end up in a situation where we essentially solidify those types of biases and make it very, very difficult to remove them from the system. So rather than making the system work better, we make it work worse, essentially. So there are significant questions to be considered about the appropriateness of the uses of certain types of AI tools in the context of court decision making. So all of this raises questions about whether or not we need to think about regulating this type of technology. Should we be developing legislative frameworks to govern this? The European Union is working on a regulation broadly on AI, which will capture many of these systems. But perhaps we need something more specific to look at the legal profession. The Law Reform Commission has recommended that we update our law a little to allow for digital audio recordings to be used as evidence, and to make more use of digital signatures, which are not permitted for certain important types of legal transactions. This was an issue during the pandemic when people would need to sign documentation. Solicitors were having to hand things in through car windows and so on, so that these things could be done in a distance fashion. And perhaps there are aspects of this that need to be modernized. But we need to think more carefully maybe about the legal profession specifically. And we have a sort of a hybrid model of regulation here in Ireland. Most jurisdictions either have a general prohibition on holding oneself out to be a qualified lawyer, a practicing lawyer, or we also have, or there will be a list of reserved activities which nobody except a qualified lawyer can engage in. We prohibit both here. And perhaps we need to look at that a little bit more closely, because there's a delicate line to be walked here, I think, between, on the one hand, ensuring that the public is protected from legal services tools that are being developed by people who are not sufficiently knowledgeable about the law, or who are not governed by professional codes or codes of ethics, and therefore provide a poor service. And on the other hand, ensuring that there is still scope for innovation, and there is scope for new technologies to come along and perhaps reduce the cost of legal services or increase efficiencies or whatever, basically to provide the public with better access to justice. And experience in other jurisdictions is that different bar associations and different legal systems take different approaches to this. The French have not been keen on this and have banned the use of AI as a means of predicting judicial decisions, for example. Whereas in the UK, there's been litigation on basically a web-based service which assisted in the drafting of paperwork for non-contested divorces, which is held to be okay. In Florida, there's been an effort by the Bar Association there to prevent an online service that would help in the contestation of traffic tickets. So, some of these things might be useful, some of them might not. We need to protect the public from unscrupulous operators, perhaps, but we also need to ensure that that there is a certain amount of healthy competition out there in the marketplace. You also need to think about the software developers, the AI engineers behind this. Do we need to think about regulating these as well? If you want to practice as a lawyer, you have to be a member of a professional association. You need to have completed a certain course of education, and you're subject to a disciplinary code. You're subject to quite significant sanctions if you breach that code. Whereas you can set yourself up as an AI engineer with essentially no formal educational requirements and no real disciplinary obligations on you either. So, as these professions become more and more powerful, maybe we need to examine whether or not there's a need for that. Finally, then we need to think about AI in the sort of coalface of the legal system and the overall context of our democracy. We need to look at whether or not online dispute resolution using the sort of AI tools that I've talked about can be an effective way of resolving problems. So we have things like the Civil Resolution Tribunal in British Columbia, which uses some of these tools quite well, and can provide good access to justice at a low cost, but does require a reasonable amount of time and investment to make it work well. We also need to think about whether or not they're, bearing in mind the concerns that I raised earlier, should we think about automating judicial decision-making, replacing judges with robots is the language that's sometimes used. So there are all those concerns about biases that I already talked about. I think the fundamental issue with this is that a lot of the discussion around this assumes that you can have an artificial general intelligence, that you can develop a software program which thinks as well or maybe better than a human being. And that just does not seem to be realistically achievable, certainly not in my lifetime, I don't think. And there are many other things that judges do beyond their work, simply in terms of giving judgment. They help to manage the courts, they help to oversee how they function. They have an educational role, they have a role in terms of assisting in policy development, all of which are much broader than simply listening to legal arguments and giving judgment on that. So I'm not sure that we'll see robot judges anytime soon. So just a couple of things quickly to wrap up, I suppose. There have been some important reports on this. The European Commission for the Efficiency of Justice, which is part of the Council of Europe, has put together an ethical charter on the use of these types of systems in the legal context and has put forward a set of 5 principles, which I think are good and sensible and should underpin any developments in this area. There is also a very new development, which is the rules as code idea, which is that as you're drafting legislation, in parallel with that, and very much with the two things informing each other, you develop a software implementation of the rules that are in the legislation, so that you can test out how this new law would actually work in practice. And then when the law is passed, you can make that software implementation available online so that developers can include it directly in their other software tools, and be sure that the code that they're running actually really mirrors the law and the way in which the law is supposed to operate. So this could have a lot of benefits in contexts such as tax, for example, or social welfare, which are very calculation-heavy areas of the law, and could lead to some efficiencies. One of the ideas that this leads to is the idea that not only might we replace judges with robots, but we might be able to replace legislators with robots. One of the things that I'm supposed to do as part of the fellowship, but has been held off because of the pandemic, is to present this paper to the members of the Oireachtas. So I am curious to see how well they receive the idea that they might in the longer term be replaced by robots. I also don't think that's terribly likely though. So I think their jobs are safe too. To conclude then, and to hand over to people for Q&A, I'm just going to end with this quotation, which comes from the Council of Bars and Law Societies of Europe, which essentially says that we're at the early stages of this, we need to think carefully about it, and we need to engage in debate and discussion, because we don't essentially want to throw out the baby with the bathwater. It should not be simply a matter of going for faster or cheaper court processes or legal processes. That we need to make sure that we respect and protect fundamental values, ethical standards, that we protect the rule of law, that we protect the democratic process as we make use of these tools. So I think that legal technology has a lot of potential benefits in terms of economic activity, in terms of access to justice, in terms of many other things, but it also has many potential pitfalls, and we need to tread carefully. So with that, I will stop the presentation and would welcome your questions and comments. I see one question in the Q&A there. And if you have other questions, if you want to put up your hand or type in the chat, we can take questions by unmuting, or we can you can type whatever you're comfortable with, and I will do my best to answer them. So just turning to what's in the Q&A. So as medtech evolved, liability has been devolved between the clinician and the medtech provider. How do you envision liability in terms of professional indemnity evolving as AI-supported initiatives advance into the legal domain? So that's an interesting question. I mentioned that there is that the European Union is working on AI regulation, and I think some of the answers to that question will emerge from that. The regulation as it currently is drafted, as far as I understand it, basically it tries to put liability for AI tools into the same sort of categorization as product liability, at least in terms of civil liability. So you might have liability to a regulator for putting an AI tool on the marketplace that hasn't been properly tested, or where you haven't thought through the potential negative implications. But you could also be civilly liable to individuals who have been harmed by the tool. So I would guess that it will probably evolve in a way that is similar to medical technology, because it will become part of or it will fall within the product liability frameworks generally. But there are different ways in which it could work out. And I think that one of the things that is interesting about this here in this context, in the legal context, is that you have this profession which is already quite well regulated, and where liability is clear, and lawyers will have insurance and so on in place. But you might have startups and so on moving into this space and providing maybe direct consumer-facing services without having lawyers involved, or minimal involvement of lawyers. So that gives rise to one concern. But the other thing that is not really clear to me is to what extent practitioners are liable if they use an AI tool or a software tool that is in some way deficient. Coming back to what I said at the beginning of the presentation, one of the things that I'm interested in, and I don't really have answers for yet, is to what extent do practicing lawyers have to have a new set of skills and a new set of awareness around software tools, so that they understand the risks and the potential downsides of applying these things in practice. I hope that answers the question. So Noel Carroll also asks, we can place a lot of trust on AI solutions, although we do not have the expertise to interrogate algorithms and so on. In your opinion, where does responsibility lie for the various use and the consequences and disputes driven by AI? So the adopter, the creators, or the users? I think that's going to be a very context driven question, because the various types of tools and the context in which they can be used and the ways in which they might be misused are going to vary quite a lot from case to case. I think it's going to be a while, as I've talked about already, before we really see how this pans out in practice. But I think there's a difference between, or you can see situations in which you could have an AI that's put on the marketplace and hasn't been properly tested or properly thought through. In that case, it's the developer who's clearly liable. Or you might have an AI that is properly thought through, but is being used for a purpose other than the one for which it is developed, in which case then it's the adopter. The adopter and the user might be the same. It might be used by a particular law firm, but you could also have a context in which, you work in a large organization, you're told you're using this tool, you're using it to the best of your ability, you're being careful. or perhaps not. And this again comes back to the question I continue to ask myself, which is, do we need to be providing our graduates with a different set of skills and a different set of awareness around these tools, so that they can be sure that whether the tools they're using are appropriate or not, they're at least using them in an appropriate fashion. So thanks very much for those questions. I'm not sure if anybody has any other questions. You can type in the chat, or you can type rather in the Q&A, I should say, in the Q&A tool, or you can raise your hand and I can unmute you if you want to ask a question directly. So I see a question there from Greg on smart contracts. Yes, smart contracts are dealt with, I think, a little bit in the paper. I should actually move on that slide. So sorry, I should have brought this up a little while ago. If you're interested in knowing more, there is a spotlight paper which is available on the Oireachtas website, which sets out, there's more in that than I was able to cover in the presentation. So you can read that at your leisure later, or you can drop me an email too if you have particular questions. Smart contracts I touched on a little, and I have done some minor research projects on blockchain. Smart contracts, I think, have a certain amount of application in certain contexts. They certainly get a lot of attention at the moment, and there's a lot of discussion around them. I think there are two major problems with smart contracts as a large-scale solution to systemic issues, or to whole areas of commercial activity. The first is that coding software is very difficult, and some of people who are working in the blockchain context are discovering that now to their cost. We have seen some instances where there has been large-scale fraud, essentially, or the misappropriation of value through bugs in smart contracts. Now, the argument could be made that the smart contract is the contract, and if you're able to move value around while keeping within the what's set down in the software code, then you're not really engaging in fraud. But nonetheless, it's clear that from some of the examples that have happened, that what took place wasn't what was intended by most of the people who were involved in the contract. So getting a smart contract right, making sure that there are no bugs in it, making sure that there aren't ways in which value can end up locked up, which has happened, where the code just sends the blockchain data to the wrong address and it can't be retrieved, or where someone is able to exploit a weakness in the code and remove that value and appropriate for themselves. That's one problem. The other issue with smart contracts is that the day-to-day life of most commercial contracts is very social. In other words, the black and white letter of what might be in a contract is generally not what will be applied day to day between businesses. Sometimes many major contracts are not actually written down. It's on the basis of a conversation or maybe a handshake. But even when it is reduced to text, how it might be applied will not correspond with that. And if there are issues, they're often resolved informally without direct reference to the what's there in black and white. So what I'm trying to say there is that a smart contract in which everything is thought out in advance and is reduced to software is not how business people often deal with each other, or even how consumers deal with businesses. There will be ambiguity and vagueness, and sometimes that's actually useful as a way of getting to an agreement, or because it's too much trouble to work out exactly how situations should be dealt with in the contract. And when difficulties or when difficulties arise, the parties to the contract will often want to be able to change what's in the contract to deal with the new situation, because their understanding might have moved on. You know, they've been dealing with whatever the other party is for a couple of years, and they've just developed their own understanding. There's more trust or less trust or whatever. The context is different. So I think that smart contracts might have application in some limited situations, but I definitely don't think that they are capable of replacing large areas of commercial law. And one of the things that one encounters reasonably often if you're researching in this sort of law and technology interface area are predictions that we will be able to do away with lawyers, or we will be able to do away with judges, or whatever. And a couple of years later, it turns out that those predictions just aren't true. So I suppose, long story short, I'm reasonably skeptical about smart contracts. Thanks for the question, though. Does anybody else have any other questions? You're welcome, Greg. Okay, I think that we've maybe exhausted the questions from the audience. So I thank you very much for coming along. Thanks for the questions and the discussion. I hope you find it of some interest. Thanks for giving up some of your lunchtime for this. No, one other question just coming in through there, sorry. Charles Arkin says, your idea in the application to taxation and social welfare would result in a very rigid application of the law. That could make for very quick decisions, eliminating stability as found with universal credit in the UK. What are the implications for this in future policy making? Yes, so that is a very good question. And I didn't go into that in detail. I was coming towards the end of the presentation, I suppose, but yeah, there are very significant concerns around that. There's significant concerns around really codifying and digitizing any aspects of the operation of the legal system, because particularly the common law puts forward as one of its great advantages that it is flexible and that it learns. And if we reduce it all to software code, then it becomes, as you say, very rigid and very inflexible. It is, I think, useful to reflect on the experiences with social welfare in Australia, particularly. There's also been some issues in the Netherlands, but in Australia, the social welfare system was largely automated, and particularly the debt collection aspect of that, the nickname that's given to it is robo-debt. And what was happening was that people were being sent very threatening letters by the Social Welfare Administration because something about their circumstance might have changed, or it turned out they weren't eligible for some source of funds that they'd been receiving or something. The whole system was quite automated. It was very difficult for those individuals who already probably would find it difficult to engage with a big bureaucracy to get through to a human and resolve this. And when they didn't pay, often because they couldn't pay, because they simply didn't have money, they would get progressively more threatening letters and would then be referred into a debt collection process and into courts and so on. And it created a huge amount of stress, caused significant harm to people. It drove some people to suicide. There are really big questions, I think, that needs to be asked around that. And one of my concerns in this area is that I think that policymakers don't always necessarily understand it. I think that we are easily led astray by the hype around the technology, or by the by the promises that are made by vendors. And I'm not for a moment doubting that the technology can be quite powerful and quite useful, but I think we do need to be careful about what sort of systemic implications this might have, and whether or not we might be looking back in 10 or 20 or 30 years and wanting to make changes to the system, but not being able to do so because everything has been essentially converted to software and has become very, very difficult to change. It is said, I've seen a lot of good writing about it, but it is said that the core of the US tax code is about 300 lines of software code, and that nobody really wants to touch that. So, large scale tax reform in the US is essentially practically impossible, as well as probably being politically impossible. It is practically impossible. And I don't think that that's a good situation to end up in, where you don't want to make policy decisions because you're not confident that you can actually make changes to the software code that underlies that system. So thank you for that question. It's a very good question. A couple more questions. I seem to have spurred people on. So the argument from the other side is that a lawyer is just a piece of meat which runs legal code. The argument I'm hearing here for the value of lawyers as a class mostly privileges soft skills and emotional management. Would you see scenarios where the powerless are subject to mechanical laws, whereas the affluent can avail of the more relational advantages? Yeah, I think that that's probably correct. I'm not sure how I feel about being said that I'm just a piece of meat that runs legal code. So the value of lawyers is a class that mostly privileges soft skills and emotional management. I think that's true to a certain extent. I also think that we don't, although that might be true in practice, it's actually not something that features very much in legal training, which I think is interesting as well. I teach students how to apply some of this in a very limited way, and we use design thinking for that, which is a very emotionally centered approach. And students say that it's the first time they've really thought about emotions as students. So it's certainly there, but maybe lawyers don't think about it enough. As to the powerless being subject to mechanical law, whereas the affluent can avail of more relational advantages, I think that's the computer says no issue. One of the examples I use with students is the swipe cards gates going into the library, where if your card is out of date, you're simply not getting into the library. So that certainly can arise, and in the context of something like social welfare, the example I just talked through could be quite real. Like a lot of this, I think that with access to justice, you can certainly see where there are advantages to it and possible benefits. But if we're not careful, if we don't have the sort of debate that I called for at the end of the presentation, we could end up making some very poor decisions that we come to regret in the future. And as with many things, being rich, I suppose, gives you better access to expertise, better access to advice, so that you can continue to capitalize on that. So a more complicated and more sophisticated system can work to the detriment of people who are already disempowered in various ways by the system. Greg also asks, do you think that e-signatories will be the norm, or at least acceptable for all forms of signatory requirements? I think that is possible, and certainly the European Union has introduced regulation in this area, which does make that theoretically possible. And some aspects of that law has been reformed recently, but there are major areas that are still essentially off limits for electronic signatures. I think there would be quite a lot of work to be done in terms of convincing lawyers that these types of, and courts and so on, that electronic signatures are acceptable. There's work to be done around authentication and verification for these types of signatures. It's very slow to get a whole system, which has been there for quite a long time, involving hundreds of people, thousands of people, to switch over to something. I think the pandemic has made people much more receptive to digital technologies as a means of transacting lots of different kinds of business. And I think if we could see electronic conveyancing becoming a reality, that would be one of the major areas essentially taken care of and resolved. You know, if people are confident that they can trust the electronic signature system, then I think it will become much more widespread. So I do see that happening in the future, but I think we are probably a good 5 to 10 years away from it becoming acceptable in all types of contexts. Anybody else have any other final questions before we wrap up? Yeah, you're welcome, Greg. And thanks to Via Hearn for the positive comment also. Okay, so I think that second wind of questions has been has wound itself down. Again, if you have any quick questions for the last few minutes, happy to take them. But otherwise, just again say thanks very much for coming along. Thanks for your attention. Thanks for the questions. There's lots more food for thought if you found that interesting in the Spotlight paper, which is available on the Oireachtas website, or I can send it to you by email if you want to get in touch. And I'm very happy to discuss these kinds of questions, you know, one-on-one if you have particular interest. Obviously, if we were doing this for real, we would be maybe breaking for some sandwiches and a cup of tea, and we could have a chat there. That's not feasible here. But thanks very much in any case. It's just one last question coming in there from Ryan. When do you think the new AI laws will come into effect? My expectation is that the regulation will be finalized sometime later this year. I'd expect in the second half of this year, probably the third quarter, but I'm not entirely sure. And normally those types of regulations would then have a lead time to full implementation of something like 3 years. Okay, well, thanks very much, everybody. It's just coming up to the top of the hour, so I think we will leave it there. And I hope you enjoy that, and maybe see you again at some similar future event in the future. Thanks very much.